The topic in the materials is employment law, which is obviously a very broad issue. We're going to try to focus on sort of the intersection between e-commerce and employment law, and specifically, we're going to focus on three primary topics today. The first one is establishing and managing your company's bring your own device policy. I know this is a topic that's on the minds of a lot of in-house counsel these days, and one that can certainly be a controversial one with a lot of employees, and we're going to talk about the ins and outs, pros and cons, and how to establish an effective BYOD policy, and one hopefully that your employees don't revolt over. Then second, we're going to talk about policies and practices that we recommend establishing regarding the use of social media in the workplace and outside the workplace by your employees, and then move on more specifically to the NLRB's recent fairly aggressive focus on social media and what it means to your policies and your practices with respect to interacting with your employees on social media issues. Welcome questions as we go. Please feel free to chime in, and we can make this a discussion. It's a relatively small group, so that ought to work out well. We'll try to leave some time at the end for that as well. I have been asked to remind everyone to please fill out your program evaluations at the end of the session. Before we get started, I want to introduce my esteemed colleagues. Here to my immediate right is Tracy Shapiro. Tracy is of counsel at the San Francisco office of Wilson Sonsini. Her practice is focused on privacy, data security, advertising, and marketing practices, and she has extensive experience counseling technology clients on compliance and privacy laws and on the use of social media to ensure compliance with the FTC's endorsement guidelines. Tracy is a graduate of the University of California, Berkeley, sorry, Stanford, and a 2001 grad of George Washington University School of Law. She's a recipient of the FTC Janet D. Steiger Award and a member of the International Association of Privacy Professionals. Farther along to the right, there's Andrew Stevens. Andrew is managing counsel at LinkedIn. He's a corporate and commercial attorney with extensive in-house and law firm experience advising growing technology companies among other things, technology transactions and privacy issues. Andrew is the second lawyer hired at LinkedIn, and he's worked on every aspect of LinkedIn's hyper-growth business, so he has a nice perspective on that industry. And as managing counsel, he works directly with LinkedIn's general counsel to manage the entire legal function at LinkedIn, including a focus on a variety of areas, including privacy and employment law matters. All right, so let's go ahead and get started with one of the issues that I know, again, keeps many of my clients up at night and that I've been getting a lot of calls on recently, and that is bring your own device policies. There are numerous issues, as many of you are probably aware, that sort of strongly counsel having a bring your own device policy. Many people are still struggling with the notion of do we allow employees to use their own devices for work? That's probably a ship that has mostly sailed, but one that folks are still struggling with how to make it work. Tracy, maybe you can start us out by telling us what some of the privacy and security issues are that arise with BYOD that employers should be thinking about how to address.
Sure. So one of the first big privacy issues is your employee privacy issues. So employees, we're kind of accustomed at this point to the fact that when we're using our work computer, our employers are going to have access to what websites we visit, or if we use our Outlook to send personal emails, at this point, we've seen enough policies to show us that they're going to be looking at that. What employees aren't used to is this concept that if you're using your personal device and you connect to your network or download data, that might open you up to being monitored by your employer. They might be looking at what you're doing even with your personal information. Depending on the implementation, they could be tracking your precise geolocation data. They might need to physically access your device at some point. For example, if they get an electronic discovery request and you've got work data on there. So there's all sorts of issues that the companies need to think through with regard to their employees. You've also got user data privacy issues. So if you are a company that collects any form of customer information and you've got that on your networks and your employees are taking that and putting that on their personal devices, the company needs to be thinking through how they're going to protect the privacy of their user data and the security of that data. Employees could take it and upload it to unapproved cloud services, for example, that's sort of out of the company's control. They, of course, could lose their devices. And securing the data is much more challenging for the company when employees are using their personal devices. So with work devices, for the security team and the IT team, they've got a lot of control over what devices are connected to the network. when you introduce personal devices, they necessarily lose an element of control there. It can be harder to install security software or get updates to the personal devices. Like I said, I mentioned the cloud. So companies have to work extra hard to put policies in place to make sure those devices are secured.
And so what are some of the things that employers should be doing to address privacy and security risks with their employees?
So we're seeing companies do a few different things. As you mentioned, the ship has sailed. There are some companies that are still taking a position of we're just going to ban BYOD. Don't want to touch it with a 10-foot pole, too many compliance risks. The criticism of that is that whether you want to admit it's happening or not, you've got a BYOD program. Your employees are using their devices in this way, and they are downloading your data. So it's there, and either you deal with it or you don't deal with it. So some employers are kind of putting their toe in the water and allowing BYOD for maybe just certain employees. So they might segment off groups of employees that touch either consumer data that's too sensitive. Let's say you're in the health or the financial field, or maybe you have super highly confidential trade secrets that certain employees work on, so you won't let them work on it. And others segmented by data. So all employees can use it, but we're going to identify types of data that we're not going to allow to be downloaded. For those companies that then allow it in any way or go all in and allow it for all their employees, there are two things that you really want to think about. One is a threshold matter. You always want to have a BYOD policy that employees read, sign it, they consent to it, and you keep a record of it. And then in addition, you want to be thinking about technological solutions that can help you address the privacy and security issues.
Yeah, so one of the things we were talking about before the conference, it's kind of like people used to be with about employee email 10 years ago. They'd have these arcane policies that would say you can't use your email for personal use, which was just ludicrous, right? And you were never going to stop people from doing that. And the fact of the matter is that no matter what you tell your workforce, oh, you can't use your own your personal phone or your personal device for work, people are going to do it. And so it's a lot easier and a lot better to try to manage that, because there are a lot of pitfalls if you're not managing it that you can fall into, from wage and hour issues for employees who are using their devices to work when they're not on the clock and you don't know about it, to security and privacy issues, et cetera. One of the issues that comes up a lot and that we've seen is employee dissatisfaction with these BYOD policies. And so you try to roll out a BYOD policy that's very overbearing and arcane and says, okay, you're going to use your device, that's great, but now basically your device is our device and we're entitled to everything on it. And if we want to wipe it, we're going to wipe it, and the hell with your pictures and all that sort of thing. So how do you see employers, what are the kind of things that employers should be including in a BYOD policy to address their privacy and security issues and to sort of bridge that gap?
Right. So one thing they should be doing is making sure at this point that it's a voluntary program. I've seen clients that say this is going to be really de facto required. If you want to have any access to your email outside of the office, it's going to have to be on your personal device. We're not going to provide BlackBerries. And yes, there is an expectation that employees are, responding to emails from their bosses at night. So in effect, that's not a voluntary program, which then calls into question whether or not the consent to this BYOD policy is really, free and voluntary. So that's one thing we advise, is make sure it really is, at least at this point, when the law is really unclear, these issues haven't been litigated, at this point, make it a voluntary program. And the types of provisions you want to have in there. So on the security front, things like requiring your employees to implement certain security measures, like password protecting their device, having strong password measures like rotating passwords, kind of the same types of things you would think about for your own work policies. You might prohibit use of unapproved cloud devices so that they're not uploading data to facilities where you haven't sort of done your diligence. You want to think through and establish a policy about when you're going to remotely wipe data, if ever. So, for example, if an employee reports that they've lost their device or it's stolen, you want the employee to know in advance, hey, we might wipe your data in those circumstances.
One of the trickiest topics on the whole data wiping issue, and one of the ones that really inflames tensions between employers and employees, is when can we wipe data? And a lot of people come up with these policies and they basically want to just retain all rights. And so they have this broad policy that says, hey, you can use your device, but if we need to or want to, we're going to wipe your data. And the employer has legitimate security concerns in wanting to do that. If the data gets out in the open, they need to protect it. They don't want to have to do a giant notice. But then obviously employees don't like that very much. And so one of the things that we've seen employers start to do is have sort of a tiered policy in that respect that says, okay, we're going to give you a chance to come into the fold and give us this data when we need you to give us this data, and only if you don't are we going to wipe the data. So for example, if you've lost your device and it's gone, then we're going to be able to wipe it because you don't care, you're not going to see it anymore anyway. But let's say you're leaving the company, or we've decided there's information that's on your phone that we need back. It's our information, it's our customer information. We're going to give you an opportunity to come in voluntarily, let us go in and sort of carve out that data and take it out. Obviously, we might run into some of your personal information, but we're going to do our best to avoid that. If you don't do that and you don't agree to do it, only then are we going to have the ability to wipe your phone. But you've signed off in the policy in the beginning on the notion that we can wipe it if we need to, but we're going to have this sort of moderated approach to that. And I think that's been a nice way for employers to sort of deal with this difficult issue they're having with employees.
I just add to just the implication of having a broad policy is, you're putting that discretion in the hands of your IT department a lot of times, and that can be pretty dangerous, as most of you know. People aren't experienced with how to deal with data, and so by being more clear, you can sort of help those folks.
Yeah, and have an appropriate gatekeeper, right?
Yeah.
Don't leave it in the hands of the low-level IT guy to decide when to wipe and when they get to pull the information back, and make sure there's someone in an HR or legal counsel position that's making those decisions.
Yeah.
Exactly. I think you want to give yourself as broad a rights as possible, I think, because you can't contemplate every situation in which you are going to want to remotely wipe. So, if there's suspicious behavior going on the device, or there's, maybe a long period of activity and you can't get a hold of your employee, you might be nervous about what's going on with the device. But at the same time, I think you grant yourself those broad rights, and then you use it very sparingly as an absolute last resort when you can't think of another way to secure the device.
And it's not just wiping, it's access also, right? So it's going to come up where you're going to need, in the course of an investigation, to review the data that's on an employee's device, whether it's a harassment investigation or a security breach investigation or whatever else it is. And it's important to retain the rights to have that access. Make it clear that your employee is saying, I understand that I don't have a privacy right and that you may need to access my information. But just like any other situation where you're accessing even their work-related email, it's how you exercise that right that's important. Because even if you have, in most states, even if you have a very solid policy that says we have the right to access your data, you have no right to privacy in it, if you abuse that right, you're going to run into a privacy claim. So if you go in there and you find their personal information and you start digging into that when you have no work-related reason to do so, you run into a problem even if you've retained the right. So you got to make sure that you use it sparingly and use it for work-related reasons.
Right.
So this issue of when you have an investigation, what do you need to have prior to going in, with a relationship with an employee? Because, we come across this all the time where companies think they don't have what it takes to do an investigation.
Right. So I think you want in advance that to be in your policy, that you are going to need to have access to the device, in the event that there's an e-discovery request, that there's suspected misconduct on the part of the employee. You want to lay out all of the circumstances where you might need either physical access or remote access. And that relates back to, I mentioned there are technologies that can assist in managing your BYOD program. So mobile device management software can enable the IT people to access the data remotely without demanding that the employee hand it over, which can be important when the employee doesn't lose their device for several days while you do your e-discovery imaging. Two, if you have an employee that's refusing to hand over the phone, you still have the ability to reach out and get the data that you need. And one of the other key things that this technology can help with is that it can help segment the data. So you can have what's called a container or a walled garden, where the corporate data is on one portion of the phone that's secured, and then the personal data is on another portion of the phone that's separately secured. So that will allow you, if you need to do remote wiping, that could allow the employer to only remotely wipe the corporate data, and you won't subject yourself to a claim of, my wedding photos were on there and it's the only copy I had.
And even in that context, if you're talking about investigation, you may be needing to get into the personal data because they may be sexually harassing their coworker through their, not using their work-related data. And there was a case a couple of years ago, this comes up in two contexts, both the BYOD policy and also just your general internal computer use and access policy, right? Most companies now have these policies that say, anything you do on our work computer or using our work email system, we have a right to access. But what they were missing was this element that recognizes that employees access their own personal email on the work computer and use that. And there was a case that said a policy that just says I can access your work-related email is not enough to allow you to then go access their personal email that they used on their computer. And so we've started having companies redraft those policies in a more expansive fashion to make it clear that anything you're doing on our equipment, whether it's our computer or our handheld device, even if it's your Gmail account, if you're using our equipment and you're circulating it there or you're calling on it, whatever, we now have the access, we have the right to access and investigate that as well. Again, you want to be sparing about how you use that, and as long as you're doing it, and you want to check your state laws also, because different states have different levels of privacy restrictions in that respect. But in most states, you're going to be okay as long as you have a solid policy in that respect, and as long as you're using it in an equitable fashion. Yes, sir.
Question. You mentioned a good example there in terms of allegations of sexual harassment.
Yep.
You discussed policy and consent, but I'm curious if you could maybe go into a little more depth about, depending on what the company's policy says, to what extent in that kind of an allegation can the company, in a sense, compel the employee to surrender their mobile phone where there may be evidence related.
Yeah, and the compelling to surrender is harder than the searching, right? So what hopefully you have as a company is the ability to search it without compelling them to surrender the device. So if you have a policy that allows you to search, and let's say the allegation is that I've been getting these sexually harassing emails from their Gmail account or texts from their private account or whatever, and they've been doing it from their work phone or their personal phone that they're using here. Hopefully you're in a situation where you've set yourself up in advance to where you can access and search that information without having to get physical consent from the employee, because ultimately you're not going to be able to force that employee to go home and get their personal phone and hand it to you. What you can, of course, do, though, is if you have a good policy that's there in place that makes it clear that you have a right to access that information, and you have a good reason to access it, i.e. this harassment allegation, is you can strongly encourage them to do that on penalty of termination if they don't. So in other words, okay, you're not going to give us access to this information. We're going to have to make assumptions about what's on there, and we're going to have to make a termination decision against you. So, but only if you've got a very well-worded policy in advance can you do that.
Actually, if I could follow up, if you
Yeah.
have a well-worded policy, and I don't mean in terms of the employee going home to get it, but let's say that they have their cell phone with them, and there's a suggestion that
Yes.
maybe text messages or other things that may be relevant to
Yes.
this allegation. If the policy covers it, to what extent do you think that it's not to physically take it
Yeah.
from the employee, but if basically you demand that the
Yes.
employee surrender it, on the site they have it with them, to what extent is that appropriate, or what risk does the company have in telling the employee that they have to do that?
Yeah, it's a balancing act, absolutely, and I think one where there's not necessarily a bright line, but one where a lot of common sense needs to be used in terms of how far we go. So for example, maybe instead of saying, give us the device and we're going to take it in the other room and search it, maybe you allow them to open it up and let you search it in their presence so that they can see what you're doing. Anything we can do to sort of moderate the privacy intrusion while getting at the legitimate employer right to know is going to help us bridge that gap. So if we do that, if we've got a good privacy policy, and ultimately if they say, no, I'm not going to let you do it, you're not going to arm wrestle them for the phone and take it, but you might say, look, if you're not, then we're going to have to take that into consideration, and we may need to take disciplinary action up to including termination. I think that's how you bridge it. It's a difficult issue, but you do need to make sure you're looking at state law issues on the privacy as you implement that policy and as you engage in that. Yes, ma'am.
I have a quick question about the segmentation. So if you do segmentation on a device with private data being segmented out, aren't you potentially creating a expectation of privacy with respect to that data so that we wouldn't be able to search that data?
Well, that's the idea, right? That's the idea, is that you segment in order to not have to look at the personal data. So that, one, if you need to do a remote wipe, you could just remote wipe the corporate data. Two, if you need to do a data collection, you can just collect from the corporate side without the data.
But I think we've done two things. We've segmented so we can avoid getting into it and protect that if we can, but we've also made clear in our policy that we may still have a reason to go into the personal data in certain circumstances, like the sexual harassment discussion we've been talking about. And so you sort of created a tiered system, right? We're protecting it to the extent that we can, so we're not getting into it when we don't have to, but we still have the right to get into it if we need to for these other limited purposes.
And so my question is you think that the privacy, the policy that you have the employees
I think it is, as long as it's drafted clearly, right? So because to the extent that you can have a policy that makes clear we have the ability to access this information, there's no right to privacy in it, you're still going to have that. And you're going to say, we're going to segment this so that we can avoid getting into that if we don't have to, but be very clear, we have the right to, and you don't have a right to privacy in it if you're using this phone for our purposes. And as long as there's a situation where they're the ones that have crossed the line by using the personal part to do something in the workplace, like harass a coworker or whatever, or there's an allegation that that's gone on, then we're going to have a right to sort of take a little adventure into that private part of the data for that limited purpose. And I think in most cases, in most states, you're going to be okay as long as you're careful about how you do it.
Yeah, but you don't want the scope of your search to exceed a legitimate business interest.
Exactly.
So, for example, some companies will track your GPS location in order to, for example, they'll only allow access to certain corporate apps when you're on the company's campus. That way, if you leave, you lose your device, there's no access to that corporate data. That would be justified. What wouldn't be justified is then tracking their GPS location everywhere they go all over town. So you want the scope of the monitoring and the scope of the searching to be very narrowly tailored, and you want to be able to have point to a legitimate business reason for every piece of data that you accessed or monitored. And one other thing I would throw in is, we have very much a notice and consent regime in the US with regard to privacy issues, so you can solve many, if not most, employee privacy issues by giving adequate notice and getting employees to consent. The same is not true in other countries, especially in the EU. So that's one thing to keep in mind is it's very hard, if not impossible, to create a uniform company-wide policy for BYOD if you're a multinational corporation. So in the EU in particular, regulators there are very skeptical of the concept of whether employee consent with regard to their data can ever be freely and given freely and voluntarily. So, if you were to put provisions in your European BYOD policy or in one uniform company policy that said you have no expectation of privacy in your private data, we can, monitor and wipe and access anything we want, those provisions most likely would not be upheld in the EU. And you also have issues in the EU of transferring of data, transferring employee data from the EU outside of the EU. That's another issue where the DPAs have made it clear employee consent is not going to be a reasonable basis for transferring that data. So keep that in mind, that's a very US-centric model.
So what do you do with it? Do you not let your European employees bring their own device?
No, I think you have, you either can have, one policy where you make very clear, where permitted by applicable law, or, if you are a resident of the European Economic Area, then the following rules apply, but you have much more tailored monitoring and searching there. So, you really need to have a legitimate business reason for...
It's such a Pandora box. What do you do with a U.S. employee whilst in Europe, where they, did have their device, but they're, subject to European laws because they're on business, whatever. It's complicated.
It's very challenging. I mean, really all privacy and data issues, are global now. The same even with, with your user data. Where is a U.S. employee, U.S. user? Where is a European user? They move around. Yeah, it's challenging.
Well,
I guess what's confusing me about the sexual harassment scenario is if we take it to its extreme. So let's say the policy, the company policy says if there's a business implication in your own personal device, this is not a BYOD device. So they have two devices, one that they use for company purposes, one that they don't, and then the sexual harassment claim relates to their personal device that they never use to access the network. And they, the allegation is that they're text messages from the personal device. Does that mean just because it's in the policy that you can make them show you their phone?
it's a hazy issue, and the farther you get away from that, the harder it is to deal with. And at some point, you get to the point of, usually if you've got a harassment allegation that's involving a device, we've got a complaining party who's showing you, here's what they sent me from their device. And if the employee is not willing to let you look at the device, if let's say they say, no, that's not mine, that's fake, they made that up, they trumped it up, and yet they're not willing to show you on the device or let you have access to it, you've got a decision to make in terms of who's the most credible witness here, and you may just have to make a decision without looking at it and say, look, we can't force you to give us your personal phone that when you were off hours, you allegedly sent these messages to our employee. But if you don't, we're going to take that into consideration in what we and how we look at the circumstance, right? And we better move on to the next topic, which is social media. This is, I know, one of the topics that most frequently sees employees and employers at odds these days and is becoming more and more a heavy topic of litigation. So I'm going to turn to Andrew and ask, does a company need a separate social media policy? And if so, what are some of the critical things the employer should consider in implementing such a policy?
Yeah. Well, obviously, I'm going to say yes, because otherwise we could move on to the agenda. But yeah, no, you absolutely do need. I mean, it doesn't necessarily need to be a separate policy, but part of your communications policy really has to address social media. I think in today's era, that's an obvious statement. And the reason is it's different from the regular communications policy. Is communications policies really prohibit people from speaking on behalf of the company, and you sort of say, okay, only these 2 or 3 folks can actually talk on behalf of the company. And with social media, you actually want all of your employees, or most companies anyway, want all of their employees sort of participating in social media on behalf of the company. It's sort of an extension of the company's brand. And companies have reluctantly sort of acknowledged that, yeah, it is beneficial for us to have our employees out there. So then on behalf of the company, you have to actually tell those employees what they can and can't do and give them advice about sort of good use of social media, and then obviously the flip side, what they shouldn't be doing. And frankly, employees don't always get the fact that when they are speaking in a social media context, that they are speaking on behalf of a company, right? They don't always think, I'm actually a representative. What people used to say, even at a cocktail party, you're representing your company. Well, on social media, you're going global with your representation, but you're always representing the company. I used to say always, but in a professional context, you are. The most important thing when you are putting in place that social media policy is to remember what your company's culture is, and the policy has to reflect that culture. For example, LinkedIn, I think most of you know it, professional networking company. We can't suddenly say, okay, no social network use during the day at LinkedIn, right? You're sort of defeating the purpose. In fact, I encourage all of you to be on LinkedIn all during the day. But seriously, I mean, you have to sort of, acknowledge what your company's culture is, and then have a policy which is reflective of that culture. And even the way it's drafted, even the way it's disseminated needs to reflect how you do business as a company. Most companies these days, you can't be so heavy-handed about social media. Like 5-10 years ago, people were like, hey, you can't use it at work. We don't want anything to do with it. And now that's just not going to work. To I think Greg's point earlier about people not using email for personal use or using your work computer for any personal things. Be realistic about it. I mean, people are going to be on social media, whether you like it as a company or not. So you better deal with it.
Draw a line somewhere between occasionally hitting Facebook on a break and running an eBay store from your desk.
Exactly.
Right?
Exactly. Yeah.
What are some of the common mistakes that employers and employees make with respect to social media and the enforcement of their social media policies?
Sure. I mean, we've all heard the social media horror stories, about people making mistakes with social media. My personal favorite is a PR exec who was hired by FedEx to come in and train the FedEx comms team on how to use social media effectively. And he landed in Memphis, Tennessee, where FedEx is based, and tweeted, a true confession, but I'm in one of those towns where I scratch my head and say, I would die if I had to live here. And needless to say, the people who hired him actually saw the tweet and were wondering, we hired this guy to teach us about our social media policy. Just sort of a classic sort of faux pas. And there's, I'm sure all of you have lots of stories, and I don't want to spend my whole time talking about those. But the critical thing is that employees just need to understand the concept that social media just gives them another way that they could screw up, but you just have to understand it. You're always going to be your posts or your tweets or whatever they are always going to be reflected on both you and your company. So think twice before you start tweeting. And as employers, I think the biggest mistake we make is not arming our employees with the right knowledge. Training them, making sure that they're fully cognizant that they are speaking on behalf of the company. And if you make some post or you see some group where they're talking, that they're maybe talking about your company in less than glowing terms, you know, if you do jump in there, make sure you're clear about who you are and why you're saying it. And you know, frankly, in most cases, you're going to want to check with your comms team before you do jump in to those types of forums.
And one of the biggest problems I see from an employment law standpoint is there's just still this glaring, gaping disconnect between employers and employees with respect to what the expectations are of employees and their social media usage. So many employees still have this knee-jerk reaction that I'm at home, in my basement, on my computer, I'm on Facebook, I can say whatever I want to say, and why should my employer have anything to say about that? And many of them say, oh, I have free speech rights, right? Which of course they do, and then their employer has a free speech right to fire them for what they say on Facebook unless they're a public employer. But there's this gaping disconnect between the employers and the employees. And so one of the best ways to fix that disconnect is with the social media policy and having a good one and rolling it out and making sure that employees are aware of it. And not just aware of what the do's and don'ts are, but of the whys of that. Because there are good, rational reasons why employers want to have some control over what their employees do on social media, whether it's they don't want them sexually harassing their employees, they don't want them disclosing their customers' confidential information, et cetera, and helping to have that dialogue in a way that's not overbearing but friendly is helpful. What would you say, Andrew, are some of the critical elements that an employer ought to have in their social media?
Sure. So certainly the theme is this concept of respect and protect. You know, respect the community that you're speaking in, which, you know, with social media policy or social media is very large, and you know, use good judgment when dealing with that community, and protect your customers and your employer. Always be thinking like this reflects on both me and, you know, if I'm talking about a particular customer, it reflects on that customer relationship. So eight quick things that I would sort of definitely think about when you're putting together your policy. Certainly the first and the top is protection of confidentiality and privacy. You know, that respect and protect, knowing it's someone else's, it could be someone else's data or idea that you're talking about. Be very cognizant of that, because obviously your audience is global. It's usually permanent. You know, once it's out there, it's out there. And it's going to be associated with both you and your company. To Greg's point, I think if you think for a minute that you can go home and you know, you're the CEO of LinkedIn, you can go home and write on Facebook something. If you don't think that's going to be attributed to your company, you know, I think you're mistaken, right? Obviously, there's legal impacts of this all over the map in terms of, you know, trade secrets. You know, you can think of HIPAA rules. You could think of the SEC issues which pop up. Patentability issues, maybe, you know, not to mention your own comms team's you know, priorities in terms of what they want spoken about and whatnot. The second thing I would certainly add is that employees are always going to be personally responsible for what they do. You know, let's make that crystal clear. You are personally responsible, even though the company, it might reflect on the company. You're responsible for your own actions, and you're not going to be able to hide behind the company and say, "Oh, I was just doing this as part of my job." You know, it's not me speaking. It's going to reflect on you, and you're going to face the consequences if you do something crazy. And policies which could pop up, you know, from your employer are things like conflict of interest, you know, code of business conduct, even IT security. You know, all these policies that could be tripped up by what you do in social media. The third, I won't go into too much detail because we've talked about it a lot, is you're a brand representative, and you know, we've all experienced good customer service and bad customer service, and we know what the difference is. And you know, social media gives you another avenue in order to promote your company, and always be thinking you are a brand representative as an employee. And fourth, I touched on a little bit earlier too, is transparency. Like the days of anonymous social media use, I think, I mean, are not completely over, but you know, be very, very clear about who you are, where you work, particularly when talking about company issues. You know, so like jumping into a forum and saying, you know, great things about your company in an anonymous name, and then, you know, people are going to find out who you are, and it turns out you're the CEO of Whole Foods or whatever that, you know, way back. Those types of things, you're not going to get away with that, you know, and so be transparent. Tell people who you are and why you're speaking. And you know, if you want to say, this is not my employer's opinion, this is my opinion, that's fine. I mean, you can usually get away with doing that, but be clear about it. Be upfront. You know, the next one, the fifth issue, use of company resources, and this goes to the sort of the wage and hour issue. Like if you are, as an employer, if you're encouraging employees to use social media, you know, it gets a little hairy if they're using social media at night, like after their 8-hour day, and you've encouraged them to do that, it becomes a bit of a question. I don't know if you've encountered that, Greg, or not.
No, it's an interesting, it's a very interesting one, and the question is, how far can you go, and how specific are you getting in what you're asking them to do? If you say, hey, we think it's great that you use social media, and feel free to talk about us when you do it, that's one thing. If you say, hey, we'd like you at least once a day to spend 15 minutes, going on and promoting our brand on your social media site, and they're doing that at home, then you got to pay them for that. And it's a sliding scale, I think.
Yep. Yeah. The sixth thing is a difficult one to deal with, and that's ownership of the account. There's been a few cases about who owns, your followers on Twitter, or who owns your LinkedIn account, things like that. All I would say is think about this one up front and decide what you want to do. There are certain accounts you're going to want to own as a company, obviously. I wouldn't advise to let anybody in the company use the company's name as part of their profile unless the company's going to own that, because obviously people leave with their credentials. So unless they're authorized to speak on behalf of the company and use that company name, don't allow them to do that. And if you do authorize them, make sure it's crystal clear that this is, you're doing this on behalf of the company, and the company's going to own this going forward. That's a very sort of important thing to deal with, but it's not always crystal clear, because obviously a lot of social media is never going to be owned by the company. And as a LinkedIn employee, I would say our view is individuals own their profiles, right? That's the way we see things. But it could get tested and could come out with the wrong set of facts. It could come out a little bit differently. The seventh thing is just to remind employees that when they're on social media, they need to be the eyes and ears of the company, right? If they see something that's wrong, don't just jump in and fix it. Go through the right channels. Tell your comms team, look, that there's this story is bubbling about X, Y, and Z. We need to jump on this. But if you jump on it as an employee, or if you're telling them, things aren't going to go that well, you really get somebody who's trained, and maybe the answer is, we know about this story and we don't want to touch it. We're just going to leave it. Or someone who's thought more about it is going to jump in. But just be those eyes and ears. And the last thing is just the golden rule, which I think covers a lot of what we do as lawyers, which is just make sure people are using good judgment, right? It's the Wall Street Journal test, or the don't be stupid test, whatever you want to call it. When you're using social media, just carry on as the rest of your life. Use good judgment. Don't do something that's going to reflect poorly on you as an individual or the company.
Andrew, we talked earlier in connection with the BYOD devices about making sure that we have good policies that allow us to access our employees' information that they're using on our company computers, company devices, et cetera.
Yeah.
We should also be making sure that we collect their social media passwords so that we can get on those, right?
Not quite so fast. That we actually do. We do talk later, about getting people's credentials. I can just touch on it quickly now if you'd like. But there are laws, certainly in California and I think 9 other states, about not asking for credentials for employers, employees, job applicants, and even university applicants. You can't sort of use social media as a background checking method for folks coming into your organization. Now, there are some provisos there, like be careful that these people can still do public searches. They're not banned from using Google.
Yeah, I was going to say we'll talk about that, because I actually give an hour-long talk on using social media and Google to do background checks, but we can no longer use passwords to do it.
Yeah, you can't use the password, but what's public is public, and people are allowed to use sort of the public, which can be just as damaging, but you don't have to give over your credentials.
And it's an interesting dichotomy, because there's this proliferation of these new laws. I think there are 9 currently, 28 proposed, a bunch of new ones just proposed in 2013 that say, as an employer, you cannot demand or request passwords to social media sites, either in the onboarding process or once they're employed. But so we're in this situation where, you can get in their email accounts to search if you're conducting a harassment investigation, but you can't ask them to give you their social media password, even though a lot of the harassment that's going on now in the workplace is happening over Facebook and these social media sites. I can't tell you how many calls I get where the employee has printed out some posts and said, hey, this person is harassing me over Facebook or over some other social media site, and then many of them result in terminations.
So let me just jump in, because there is a proviso in California that if your investigation is related to some employee misconduct, or obviously, some legal investigation, you are definitely allowed to get the credentials in that case and look into it. At least in California, you're allowed to fully investigate, but your investigation has to be focused on the allegations. You can't then say, oh, you did this at a fraternity party 10 years ago. I didn't realize that when I hired you. I would never have hired you. You can't do that, obviously. But you can investigate and use those credentials to investigate.
And it's designed to stop that sort of thing, the
Yeah.
background check. But,
Yeah.
and
Yeah.
particularly in other states besides California, there's overlap into, and it puts some significant prohibitions on what employers can do, even in the employment context. This is a great segue into our next topic, and that is sort of the NLRB's recent forays into the social media space. I'm sure many of you have seen a lot of the media about the NLRB's activity, where they have basically been slapping down employers who discipline and terminate employees for what they say and do on Facebook. And also they have been speaking out directly on what employers can and cannot include in their social media policies. In both contexts, often in a very, what I would say is an overreaching fashion, to say the least. And we're in this interesting situation where we don't know whether or not their pronouncements on this will ultimately be upheld by a court yet or not. So we're in this difficult situation. What I would say gets us here is the fact that, as I talked about earlier, there's this disconnect between employers and employees about what they can say and do on social media at work and at home. And as many of you are probably acutely aware, hopefully not from your personal activity, but from many of your friends, drunk Facebooking is the new drunk dialing. So we have employees every night who go home and get a couple of cans of beer in them and start typing on Facebook. And they get a little head of steam going and they start talking about their employer. And maybe they're talking about their coworker. Maybe they start going off on their manager for something that happened that day. Maybe they start talking about an interesting scenario that happened to them at work. And next thing you know, they are inadvertently in a drunken haze disclosing confidential customer information. There are a million different ways that employees, usually under the influence of alcohol, violate their employer's policies while they're at home at night on their laptop. And so employers have started having these policies and have started taking action against employees for doing this. And it's usually through discipline or termination for violation of their social media policy or some other policy. So what the NLRB has done is they have taken what's called Section 7 of the National Labor Relations Act. And for those of you who are not employment lawyers or don't know what that is, basically it's a section of the National Labor Relations Act that says employees who are not management level employees have a right to get together collectively and talk about their wages, benefits, and other terms and conditions of their employment without fear of retribution. And it is that last part of it that the NLRB has seized upon and has said social media posts that then get joined in on by other employees are protected concerted activity if they're talking about anything related to employment. And they have taken this concept and they have mushroomed it in an out of control fashion. The reason the board is doing this, by the way, is relevance. So the unions have been dwindling and their relevance has been dwindling. And so they're trying to reach out to the latest, to the new sort of millennial generation and say, we're relevant to you because we're going to protect you in what you do and say on Facebook from action by your employers. And so they've gotten really aggressive, and there have been a series of pronouncements by the NLRB's General Counsel and then actions by ALJs and ultimately by the National Labor Relations Board itself, striking down terminations and striking down policies as violative of Section 7 of the NLRA. This come in two contexts, the policy cases and the discipline and discharge cases. Talk about the first case, which came out in 2012, which was the Costco Wholesale Corp case. Basically, there was a policy. These policy ones are the ones that really, I think, I find truly amazing, because social media policies that say things that seem perfectly rational and innocuous, and the NLRB finds a way to say that they're chilling of Section 7 rights. For example, in the Costco case, Costco had a policy that said it prohibited employees from posting electronic statements that, quote, damage the company, defame any individual, or damage any person's reputation. Seems like a reasonable policy to have. NLRB said, absolutely unlawful. You can't have such a policy because it's chilling of Section 7 rights, because an employee might want to talk about what's going on in the workplace in a way that could theoretically damage the company. If their manager's being mean to them and being mean to a group of employees and they want to talk about that, that's protected, but that might theoretically damage the company. So you can't have such a policy. Also, a rule that sensitive information may not be shared, transmitted, or stored for personal or public use without prior management approval. also unlawful because, well, that might prohibit us from talking about wages and other terms and conditions. The Costco case, which was sort of the first seminal case from the board, left a number of questions unanswered that it touched upon but didn't answer, such as, is a policy prohibiting friending coworkers unlawful? What about requesting employees to report unusual or inappropriate social media activity? Seems like a reasonable thing to do. Basically, if someone's doing something they shouldn't be doing on social media, tell us about it. The general counsel has come out and said that's unlawful. It chills Section 7 rights. ALJ opinions have said no, it's not. It's okay to do that. So we're still an open question on that. Savings clauses are a big one. So anybody who has a social media policy has probably been told by their employment lawyer at this point that they ought to at least have a savings clause at the end that says nothing in this policy is intended to prohibit employees from engaging in protected concerted activity, talking about the terms, conditions of their employment, et cetera. So if anything we said above here seems to do that, we didn't mean it to, and it's an exception. The general counsel has taken the position that that does nothing to save an otherwise unlawful policy, and that if the terms in the policy are violative otherwise, that's not enough to save it. I think that's an open question. The board has not come in, weighed in on that, nor, of course, has a court. But what I will tell you is it's something that I would continue to include in your social media policies. What the one good thing, sort of good thing, that the NLRB has done is the acting general counsel has come up with an advice memorandum wherein he actually puts up a sample social media policy and goes through examples of things that he thinks are lawful and unlawful to have in a social media policy. On the one hand, many of them are ludicrous, and the things that he says are unlawful you ought to be able to have in a social media policy. But the good thing about it is he gives you things that you can put in there that the board has sort of put their stamp of approval on and gives you a safe harbor to say, if this is in there, then we're going to be okay. I'm going to go through some of those for you in just a minute. First, I want to shift over to talk about their position on discipline. So what started happening is anytime an employee says something, and these cases come up in the craziest way. So employees will go on there, and the first case that came up, the employee called their manager a mental patient, a scumbag, and a dick. And he got fired for it, which is not really that surprising. And of course, if he did that in the workplace, he would have gotten fired for it. But since he did it on social media, and since a couple of his coworkers chimed in and said, you know, yeah, I kind of agree with you, now suddenly we have protected concerted activity. And an ALJ ruled that that was an unlawful termination because it violated Section 7. That one didn't go up to the board, so we don't know what the board would do with that, but there are a whole host of cases along those lines. We finally got our first decision from the board on a termination in a case with a BMW Land Rover dealership where an employee had posted about a salesperson who had allowed a 13-year-old to get behind the wheel of the car. He turned it on, put it in gear, and had a big wreck in the parking lot. The board said in this case that it was, well, actually the same employee had then also sort of gone off on a promotion that the dealership had done where they'd had stale hot dogs or whatever, and he'd sort of put both of these in the same post. Dealership fires him for the hot dog post. Fires him for the crash post. Doesn't mention the hot dog post. He claims it's all protected concerted activity. And what the board said is, because this truly was not about anything related to terms and conditions of employment, he was just sort of mocking something that had happened in the workplace, that is outside of Section 7 and therefore not protected concerted activity. So just when we thought things were moving in our direction, we got a lovely case about liking things on Facebook. So we had an employee who was terminated for a clear disciplinary infraction at work. Employee claimed that he wasn't terminated for that reason, but rather because his coworker had posted something negative about the employer and he had gone on and liked that post. Well, the National Labor Relations Board has now told us that liking is protected concerted activity. So by liking another employee's post, we are now engaging in protected concerted activity. It's kind of spiraling out of control, as you can see. So we'll see where all that sort of pans out. But for now, you cannot fire someone for liking activity. And more importantly, in this case, he got to have his case go on and move on to the next stage because he claimed that that was the real reason why he was fired, as opposed to the reason that the employer concerted. And here's the great quote about that from the ALJ. I further find that selecting the like option on Facebook account constituted participation in the discussion that was sufficiently meaningful as to rise to the level of concerted activity. So liking is a meaningful activity these days. All right, so
Of course it's meaningful.
What could be more
What
meaningful
could be
than
more
using
meaningful?
social media to make commentary?
Yes, let's talk a little bit about the advice memorandum on policies, because I think this is important. And by the way, in your materials that are posted online, I have a copy of the actual General Counsel's advice memo, and I think it really is a good, and there are also a couple of social media sample policies that I've done that are adapted from existing policies that are in compliance with the General Counsel's advice, that I think are good sort of policies that bridge the line nicely between violating what the board says is going to be unlawful and yet still trying to say the things that you need to say in a social media policy. But just to give you a couple of examples, the board says it's unlawful to say discussions related to the employer must be completely accurate and not misleading. Okay, seems like a reasonable thing. That is unlawful according to the National Labor Relations Board because it might have a chilling effect on Section 7 activity, because an employee might be afraid if what they said was not completely accurate as they were talking about the terms and conditions of their employment, that they might get fired for it, and therefore that's unlawful. It is, according to the board, lawful to say, make sure you are always honest and accurate when posting information or news, and if you make a mistake, correct it quickly. Never post any information or rumors you know to be false about the employer, fellow employees, members, customers, etc. So again, fine line between the two, but good idea probably at this point, unless you want to be that test case that goes to some circuit to decide whether the board's pronouncements are lawful, to make sure that you're trying to follow the advice of the GC. Here's another fun one. Posting confidential or non-public customer, employee, or company information is prohibited. Unlawful according to the board. The board says it's okay to say you must maintain the confidentiality of employer trade secrets and private or confidential information. The notion, again, being that company information could include wages, terms and conditions, et cetera. All right, so we get the point of that. We have got only a few minutes left to go here, so I really like to throw it out to everybody for any questions that we have about any of the topics that we covered today. Bring your own device policies. Again, there's a good sample policy in your materials on that. Social media policies, some samples of that, or sort of the latest pronouncements of the board and what we can and should be doing as employers to deal with those. Questions on any of those topics right now? Yep.
Sorry. On the NLRB basically decisions, what kind of jurisdiction do they have? Is it just if you're a member of a union?
Nope. If you are an employee, you are covered. So typically we think of the board as covering unionized facilities, but Section 7 applies broadly to all employers, union or non-union, because basically what it does is it protects their right to organize. That's what its intended function is, to allow them to get together and talk about their terms and conditions and say, hey, maybe we should form a union. But it's much broader than that, and the NLRB is trying to make it even broader. So it doesn't matter whether you have any unions in your organization. All of the NLRB's pronouncements in this respect are applicable to your company.
Sorry, I was going to say, where's the distinction between management and sort of employees, or is there any?
Yeah, and there's a whole body of law on what constitutes a managerial supervisory employee. But basically, if you're talking about an hourly non-exempt employee that doesn't supervise people, in most cases, that's what this applies to. If you're talking about a supervisory employee that's managing an operation, then we have a lot more control over what they can and can't say than we do over rank and file employees.
What about the situation where an employer finds an anonymous posting on the internet, presumably from an employee of the company disclosing confidential information, but anonymously?
Mm-hmm.
I mean, I'm sure you could sue John Doe, get it, the anonymous name took over, et cetera, if you wanted to. But as a practical matter, a lot of these websites would have a policy saying that, as a user, you should not disclose confidential information, violate contracts by your posting. Do you know if these websites, if you were to contact them, actually would take down things like that? If you as a company say, this is confidential information disclosed, I'm not looking to sue anybody, but...
I'll give you my experience with that, and then I'll let Andrew speak to that, because he's sort of on the other side of the coin there. We find, as outside employment law litigators, that it is frequently very, very difficult to get providers to turn over that sort of information to you as part of your investigation, number one. And then in terms of whether they will take it down or not, Andrew probably has a better sense of that, but I think it depends a little bit on the content and that sort of thing. But it's a very difficult situation, right? How do we stop this from happening as an employer when we can't figure out who it is and we have no way of ascertaining who it is? we can't take any action against the employee because we don't know who did it. So how do we not only get this one taken down, but how do we stem the tide so it doesn't happen again? What are your thoughts on the?
So
other
just
aspect?
on the handing stuff over, we, I'm speaking for LinkedIn's behalf, not other companies, but we take the view that, our members, it's their content, and if someone does something anonymously, we're not going to disclose that. So we force, if someone wants to find that out, and if it's some large case, and there's avenues to subpoena us and demand, and that's the only way we would ever hand something over is if we were actually subpoenaed.
What's been your experience of the court's willingness? I'm sorry, to order that sort of information?
They certainly will. We get lots of them. I would say on a weekly basis we get lots of them, and some we turn away because for what administrative reasons we sort of say that no, that's not that you didn't comply with exactly what's needed. But there are cases where we have to turn things over.
Yeah. That's the position we take as a website as well, but more on the side of the practical matter.
Yep.
Do websites which have
Yeah.
terms saying the user shouldn't post content that violates the contractual provision
Yeah.
or something? Third party right, if the third party were to come to the website and say, can you please take that down? It's violating.
Yeah, we have a process for that where we have a form to fill out, and someone, if they will sort of verify on behalf of the company, this is what it is, this is why it's confidential, and we'll generally act on that. I mean,
Kind of along the lines of the DMCA too.
yeah, it's very similar concept, and we certainly, because particularly at LinkedIn, again, we have individual members and we have enterprises as customers, so we have to sort of weigh the balance. I would say we definitely fall on the sort of the members first. We look after our members first. So if just because they're a company doesn't mean we're going to react and say, okay, absolutely, we'll do whatever. We'll trample all over this member who did this. We're going to take a members first philosophy. But if it's a case where we can clearly see, yeah, this does make sense, and they've followed all the sort of process we've put in place, we will take things down.
And frequently for employers, it's a cost-benefit analysis because so often it's so hard and time-consuming and expensive to ascertain the identity of the person, to get the information taken down, and sort of this, how critical is it? How much is this really hurting us? Do we have client pressure to make us take it down? I mean, those are the sort of things that end up getting looked at, and sometimes it's this person just appears crazy, and they're doing things that we're just going to not worry about. So it's kind of works out that way.
A lot of my clients take that exact same position that you mentioned, that, we're just the provider. The Communications Decency Act protects us. So, if you might allege that this is defamatory or it's confidential, most of the time, many of them have sort of a form letter that they will send out saying we're protected by the CDA and we don't take down our user content. They want to be pro-user and protect them. But if there is a TOS violation that the complaining party can point to and say this is in violation of their TOS, it makes it much easier for the company to say, okay, you're not getting involved in the battle and judging, is this really confidential information? Is this defamatory? If it on its face violates the TOS, it's an easy way for the company to say, okay, we're just going to take it down. And we're not kind of opening a Pandora's box of, being the arbitrator in these kinds of disputes.
I do have one more question if we have time.
Sure.
Yeah, sure.
So say this is kind of turning things around. Say you're a provider of mobile device management software, and so your customers are employers or their HR departments or their IT departments. What would you want to see the company do? Like basically in the contract, in your form contract with your customers, do you want them to require them to have a bring your own device policy? Presumably this is for their those devices, or do you want a direct end user license agreement with those employees? And it's okay if you haven't thought about this because it's kind of a different perspective, but just
I've thought about this. I've dealt with this. I think on the one hand, if you're the provider, I think you can take the position, whether or not it be a successful one, of I'm just a technology provider. I am not responsible for the data collection. I am not the data controller here. I am just I'm a service provider to this company, and it's really up to them in terms of making decisions about what they collect and how they protect it. And that said, I always advise put in the contract that you are going to get all of the required notice and consent from whomever you are collecting data. You're going to apply with the applicable privacy laws so that if there is some kind of a violation and the employee brings a suit against not only their employer but also the BYOD company, you at least have something to point to say we thought this through, we discussed this is in the contract, the obligation is on them. They represented and warranted it, they indemnified us for it, that they're gonna get adequate notice and consent.
And I understand that people need to start going. I know we have one more question in the back. We're getting a little bit close to our time, but
Okay, yeah, I'll just make it quick.
yeah.
So particularly for companies like LinkedIn where your employees are also using your product, but I think this is also sort of more generally true. You have your social media policy. If you have an employee who is either directly communicating with customers in a way that isn't very confrontational or not helpful or what have you, do you have sort of a best practice tip on whether it's a communications legal or HR sort of response to how to manage that?
Yeah, I would say it's more sort of an HR type or even their management type issue. Like you really, at LinkedIn anyway, we really focus on, we've got to use this tool properly. If we're not using it properly, how do we expect our customers not to use it? So we do a lot of training about here's language to use, here's approaches to take. But for other companies, it is a little more difficult because, when it's our own product, we spend our whole day thinking about it and training folks how to use it. But when it's one of several other tools that people are using at their desk, it becomes a little more complicated and harder to train specifically for that interaction. That's a good point.
Well, I think we're out of time, but thank you guys very much. We'll be around after if anybody has any other questions.